Should you create a will to prevent intestacy problems? Imagine a loved one passing away without a will. Do you know who would inherit their belongings or who would be in charge of their estate? This is where a last will and testament can make a big difference. When you create a will, you decide exactly how your assets are distributed after your death. Without one, the state law takes over and determines who gets what. This process is called intestate succession. Each state has its own rules, but generally, it favors spouses, children, parents, or siblings. If no relatives are found, the estate may go to the state. Having a will means you stay in control. You can specify who inherits your house, savings, or personal items. Want to leave something to a friend, a charity, or a distant relative? A will makes that possible. It also allows you to name an executor, the person responsible for managing your estate and making sure your wishes are carried out. Without a will, the court appoints someone, and they might not be your first choice. If you have minor children, a will is essential for naming a guardian. Without one, the court will decide who raises your children, which might not be the person you would have chosen. Creating a will can also help avoid family disputes and reduce the time and costs involved in settling your estate. When there is no will, the process can take longer, often months, and cost more in legal fees. A well-drafted will can include specific instructions, like setting up trusts for children or conditions on how assets are used. It can also address paying debts and taxes, making sure your estate is handled smoothly. Overall, having a last will and testament gives you peace of mind. It ensures your estate is distributed according to your wishes, protects your loved ones, and helps avoid the confusion and conflicts that can happen when someone dies without a will. If you care about your legacy and your family's future, creating a will is a smart step in estate planning.